start. See, my name is Mahendar Bangeja. I am the senior content manager here. So most of the subjects relating to procedural law, I will be taking up for you guys. I graduated from Mumbai University, and then I did my LLM from Jindal. I was a research assistant in Supreme Court of India. I assisted lordship in varieties of judgments. I have also worked on a research paper which was represented in Moscow Convention of Execution, wherein we represented India. So thereafter, I started practicing. And now here I am teaching you guys for preparation of judicial services. I have cleared many mains. I have cleared many prelims. If I have to count, I have cleared about 16 of them. So I'm aware of the pattern that you guys face in various states, including Hindi and southern states as well. So in all states, you will have this one topic which is very important, that is cardinal principles of evidence law. Now, what are these cardinal principles? Now, see, these are the most important principles in evidence law, which are universal in nature. Whichever country you go, these principles will be there. These are namely 5 principles, and these are there in every country. In every aspect, you will find these cardinal principles or the most important principles of evidence law. Now, these principles are based on a rule which is known as rule of best evidence. ये सारे principles एक rule पे based हैं, which is known as rule of best evidence. These all principles are based on this rule, which is known as rule of best evidence. Now, what does rule of best evidence says? Your rule of best evidence says that, see, suppose you have 2 evidences in front of you. Suppose you have 2 evidences in front of you. You will choose the best evidence possible. Suppose you have 2 evidences in front of you. You will choose the best evidence possible. Suppose you have an oral evidence. Okay, you have an oral evidence and you have a documentary evidence. So your rule of best evidence says that you will choose the best evidence. So obviously you will choose a document over an oral evidence. हमेशा आप document को लोगे oral evidence के ऊपर. The reason being because a person may lie, but a document may not lie. Whatever is written in the document, it is there. So person can retract from it. Person can alter a thing, but a document cannot alter. So that is the reason. In any case, you will choose the best evidence possible. So if there is an oral evidence and a documentary evidence, you will choose a documentary evidence. So these cardinal principles are related to a lot of things, not only this documentary evidence or a oral evidence. Suppose you have a original copy of a document and you have a photocopy, a original copy, and then the second copy is photocopy. In that case, your best evidence will be the original copy. In that case, your best evidence will be the original copy. Okay. So the original copy will be the best evidence because photocopy can be altered, it can be changed. So in any case, these cardinal principles, all these cardinal principles are based upon this are based upon this essential rule, which is known as rule of best evidence, which says that in every case, when we are countered with 2 evidences of similar nature, we will accept that evidence which is best to us. Okay? Which is best to quote. Fine. So these cardinal principles have their roots in the rule of best evidence. ये जो cardinal principles है, इनकी जो roots है, it has its roots in the concept of rule of best evidence. Okay? The cardinal principle concept has its roots in rule of best evidence. Okay? Wait. So try to avoid Hindi in between. No, whatever I'm saying in English, I'm just repeating in Hindi for the convenience of everyone. It's nothing extra I'm saying. So if I'm using Hindi, you can ignore that part because I'm just repeating whatever I've said in English. Okay? So these are roots. So this principle is the rule of best evidence is the root of this cardinal principles of evidence law. Now, before we proceed to the session, we need to understand the basics of evidence law of evidence. Okay? So your Evidence Act 1872 was authored by Sir James Stephen. Now, this Sir James Stephen is the same man who finalized Law of Contract, which is Contract Act. He's the same man who finalized Contract Act. So that is the reason when you read Contract Act, you will find that the words in evidence and contract are a sort of similar. The terminologies that have been used in evidence and contract are a sort of similar because it has been drafted by the same man. In fact, when Act started, it had the element of Sir Henry Mean, and then it was finalized by Sir James Stephen. But for Evidence Act, the entire act was drafted by Sir James Stephen. And I can assure you that it is the most beautiful piece of legislation because it has stood the test of time. 150 years, still there have been minimal amendments in this act if compared to other laws. In this act, there have been minimal amendments. Okay. So the first thing that you have to keep in mind that this has been authored by Sir James Stephen. And secondly, this act is procedural law. What is a procedural law? A procedural law, there are two sets of laws. You can have two sets of laws. One is a procedural law and the other is a substantive law. So your procedural law basically tells you the procedure. So there can be two sets of law. One is a procedural law and other is a substantive law. So your substantive law creates rights and liabilities. It creates rights and remedies. It creates certain rights and it provides remedies. Okay. On the other hand, procedural law provides for a procedure to enforce these rights. Okay. It provides for procedure to enforce these rights. So basically, what does procedural law does? It completes the maxim, ubi jus ibi remedium. Where there is right, there is a remedy. So it provides a procedure to enforce this remedy. Okay, so it provides a procedure to enforce this remedy. Now the question is whether evidence law is substantive law or procedural law. See, ideally it is procedural law. But in certain matter, it has the element of substantive law as well. For example, estoppel. Estoppel is a section 115 in Evidence Act, which actually creates a right in favor of a particular person. So in certain matters, it is substantive, but essentially or primarily it is a procedural law. But in certain matters, it has the element of substantive law. So primarily है procedural, but कुछ जगह पे it has the element of substantive. So it is substantive in certain matters, but primarily it is procedural. Now the third thing is that what is the purpose of the act? See, the purpose is threefold. The act tries to do three things. First, it tries to consolidate. Consolidate means that it tries to compile. Second, it tries to amend. Third, it tries to define. It tries to do three things. First, it tries to consolidate. Second, it tries to amend. Third, it tries to define. Now try and understand what they're trying to say basically. So when they say consolidate, amend, and define, what they are exactly trying to say. So basically this act is doing three things. First, it is consolidating. When I say consolidating, means that there were already existing laws relating to evidence prior to commencement of this act. इस act के पहले भी कुछ laws होंगे evidence के. So what is this act doing? This act is basically bringing all these laws together. Okay? And indeed, prior to this act, there were various evidence law. And some laws were governed by provincial code, and some laws were governed by presidency code. And in certain cases, you applied your personal law, that is Muslim law or Hindu law for evidences, for deciding evidences. So now here it created a problem. It created an ambiguity, right? It created conflict. For provinces, there was a different evidence law. For presidencies, there was a different evidence law. And when the matters are relating to persons, so that person's particular personal law was being applicable, Hindu law, Muslim law. This created a problem. So what did the evidence law do? Evidence law consolidated all of them. And they compiled all of them and brought under one head. That is Indian Evidence Act, 1872. So what did the Evidence Act do? Evidence Act actually compiled all of these laws together and made it into one act. Okay, this is the one thing that they did. So they consolidated all the laws relating to evidence. Secondly, they defined. Now see, not all matters were dealt by provincial laws. Not all matters were dealt by presidency laws. Not all matters were dealt by personal laws. So what did the evidence law do? Evidence law defined new matters. Whatever new matters were there, evidence law defined them. They said that these are the new matters, we have to define these things. And lastly, the evidence law amended the previous legislation. So it amended the previous legislation. जो पहले चल रहा था, it tried to amend those legislations. So all the presidency laws, provincial laws, or personal laws were amended, and they were ultimately brought under the head of Indian Evidence Act. That is Indian Evidence Act 1872. So your purpose of this act is threefold. One is to consolidate, second is to define, and third is to amend. Consolidate because there were varieties of law. So it brought all the laws under one head. That is Indian Evidence Act 1872. Now, these laws were not self-sufficient. They had gaps in between. So therefore, there were new matters to be defined. So this act also defined new matters. Thirdly, these previous legislation needed to be amended. This act also amended them. So these are the three things that this act primarily intended to do. ये तीन चीजें हैं जो ये act mainly करना चाह रहा है. Fine. अब आगे बढ़ते हैं. ठीक है. So now see, your evidence law is such a law which is applicable to both civil and criminal cases. ठीक है. And it has 11 parts and it has 167 sections in total. 11 parts hai aur 167 sections hai in total. It has 11 parts and 167 sections in total. Fine. Now see, before you proceed to the cardinal principles, you have to understand the geography of the act, how the act is drafted, and the way evidence law is worded, or the way evidence law is drafted. It is very fascinating. Okay. So see, evidence law seeks to answer three questions. The entire evidence law, in fact, the entire evidence law will be answered in these three questions. Or the entire evidence law, the provisions of all the Evidence Act will be covered in these three questions. So your Evidence Act seeks to answer three questions. The first is what to prove. Okay. See, when evidence law was drafted, so your evidence law intends to answer three questions. So there are three questions before the evidence law. So now see, evidence law deals with one matter, that is proving. Evidence law, why was it drafted? To regulate proving. That how will you prove a particular fact? And what will you prove? And when will you prove? So that is the reason three questions are actually answered by your Evidence Act. The first is what to prove. ठीक है, क्या आप प्रूफ करेंगे, क्या साबित करना चाह रहे हो, what are you to prove. ठीक है. Second is how will you prove this, how to prove. And the third is when to prove. These are the three questions that are raised by your evidence law, and they have to be answered. Okay, let us see the first question, that is what to prove. Now see, evidence law says that only relevant fact and fact in issue has to be proved, nothing else. So when they say what to prove, only relevant fact and fact in issue. We will understand what is relevant fact and fact in issue a little later. We'll understand what exactly is relevant fact and what is fact in issue. But what Evidence Act is saying, that see, you are only to prove relevant fact and fact in issue. No other irrelevant fact or no other subsidiary facts. You are only to prove relevant fact and fact in issue. Okay, this is the first thing. And the second thing, it says that, okay, how to prove. So the act says that, see, you are to prove through oral evidence or documentary evidence. या तो आप oral evidence से prove करो ये facts or through documentary evidence. Now the question is, who is to prove? Who is to prove? That question is answered that the person upon whom the burden of proof lies. ठीक है? The person upon whom the burden of proof lies, that fellow will have to prove. Now see, interestingly, there are certain facts which are not which are relevant, but they need not be proved. Now when I use this word need not be proved, I mean to say that the act has given this is who to prove, this is not when to prove, who to prove. Okay, now when I say need not to be proved, there are certain facts which are relevant facts, but they need not be proved. Now when I say need not be proved, I mean to say that the court has given the act has given them a leeway that these facts need not be proved, obviously, because we don't want to waste court's time. So these facts need not be proved. Now what are these facts? The first is admissions. If a person is admitting that he has committed the offense, then you need not prove that he has actually committed the offense, or if he has actually done. If he has admitted, end of the game. So these are certain facts which you need not prove. One is admission. So if a person himself is saying that I have done this act, you need not prove anything. So these are the relevant facts. These facts are relevant, but they need not be proved. Secondly, of which the court takes judicial notice. Now these are certain facts of which the court actually takes judicial notice. Now these are basic facts. For example, sun rises in the the concept of longitude. Sun rises in the east, sets in the west. These are the basic concepts which are known to human and which need not be proved. These are the basic concepts that India exists or these continents exist. These things are not to be proved because these are of basic common sense. So these are of basic common sense. These need not be proved. The act says that you need not waste your time in proving these things. ये चीजें आपको prove नहीं करनी. Fine. So ideally, what to prove? First, you will have to prove relevant fact and fact in issue. ठीक है? First, you will have to take relevant fact and fact in issue. But there are certain things that are relevant facts, but they need not be proved. Means that the court says that we understand that these facts are relevant, but we don't want you to waste time in proving them. The reason we don't want you to waste time because these are pretty self-explanatory. So one is admission, when the person himself is saying that I have committed the offense. So you need not prove it. And of the facts of which you can take judicial notice, court can take judicial notice. Now these are common sense facts of which the court can take judicial notice. Court is saying, okay, fine, we are taking judicial notice that this thing exists. You need not prove it. For example, say we have 29 states. So this is a common sense fact, and this is a fact of geography. No one need to prove that we have actually. No one need to bring witnesses for that to prove that we have 29 states. So the court will take in such cases judicial notice. Court will say that we are taking judicial notice. You need not prove this fact. Court will say हम judicial notice ले रहे हैं, आपको ये चीज prove करने की जरूरत नहीं. ठीक है? So this is what is relevant. These are the things that you have to prove. So you can only prove relevant fact and fact in issue. And there are certain relevant facts which need not be proved. You are not required to prove them. Now, why you are not required to prove them? This is to save court's time. This is to save court's time. Okay. And there are certain relevant facts which shall not be proved. Shall not be proved. अब इसका मतलब क्या है? What does this mean? When I say shall not be proved, what does this mean? Now there are certain facts which are relevant, but the act is prohibiting you from proving them. Act is throwing a restriction upon you. Act is saying, fine, they are relevant, but we don't want you to prove them because there is some malice or some element of malice in these facts. For example, a confession to a police officer. Act is prohibiting you to prove that statement. even though that confession is relevant. So any statement that you are making to the police officer, though it is relevant, but the act is saying that you cannot prove this in court. You are not required. We are not allowing you to prove this in court. We don't want you to prove this in court because there is an element of malice. The police officer can force the accused to make the confession. So this is first is confession to police officers. Confession to PO. This is in section 25 and 26. And then comes your second aspect. That is privileged communications. Privileged communication. Wait a sec. I'll repeat this thing. Kindly repeat this point. This one, confession to police officer, or the shall not prove part. Shall not prove part. Fine. See, try and understand. There are three questions that the Act answers. The first is what to prove, how to prove, and who to prove. Fine. Now, with respect to what to prove, the Act says that you are only to prove relevant fact and fact in issue. You cannot prove any other fact in court of law. So only RF, that is relevant fact and fact in issue. Now the Act says that fine, you are to prove every relevant fact, but there are certain relevant facts which need not be proved. So certain relevant facts which need not be proved. Now the reason the Act is saying that you're not required to prove these facts, the court is basically saving its time. Court is saying that these are facts are so preliminary that we don't want you to prove this. So in this case, you have two facts. One is admission, and the other is of the facts of which the court can take judicial notice. So these are the facts which need not be proved by the parties. So the Act is giving you an exemption that आपको मेहनत करने की जरूरत नहीं कि एक witness लाओ इनको prove करने के लिए. You did not work hard and bring a witness to prove these things. It's fine. These facts need not be proved. We are deeming them to be proved. We are fine. So the second thing is that there are certain facts which are relevant, but the Act is strictly saying that they shall not be proved. When I say they are saying shall not be proved, it means that the Act is saying that these facts are not supposed to be proved. We don't want them to be proved. And the reason we don't want them to be proved, because they have an element of malice in them. There is a relationship, or there is an element of malice involved in that, in such facts. So the Act here is prohibiting proving these facts. There is a prohibition that yaar ye facts to aap prove nahi kar sakte. So a person is prohibited from proving these facts. Okay. So the first is a confession to a police officer, or a confession in police custody, that is police custody. Both these things shall not be proved. We are not supposed to prove these things. The second element is your privileged communication. Now the Act prohibits you from proving these things. Act says that you cannot bring these things in court of law. Now mainly Act has three kinds of privileged communication. The first being matrimonial communication. This is communication between husband and wife during the continuance of marriage. So whatever husband and wife are saying, or whatever communication they are having during the continuance of marriage, that cannot be brought in court of law, or you cannot prove that in court of law. You are prohibiting from bringing that up in court of law. Okay? Unless there is a divorce petition between them, unless they are fighting a suit amongst themselves, then it is a different question. But suppose a husband has been accused of murder. Suppose A has committed murder. A has killed B. And A is telling his wife W that, see, I killed B. And what happens? Court calls W to give testimony against A. Now here W will be prohibited from making any statement against A. She will be prohibited from making any statement. She will be prohibited from saying that this confession was made to her, because this communication between A and W is a privileged communication. privileged communication. Now, the reason this communication is privileged to maintain the sanctity of marriage. Fine. If you allow all the matters to be thrown in court, which all the communications which are between husband and wife to thrown in court, then the sanctity of marriage will ultimately dissolve, and you can see strange relationships occurring time and again. तो क्या होगा कि मैरिज का पर्पस ही डिफीट हो जाएगा और आप देखते रहोगे कि शादियां टूट रही हैं इसकी वजह से. So that is the reason matrimonial communications cannot be proved, shall not be proved in court of law. The act is prohibiting कि boss you cannot prove. And the second is attorney-client privilege. Second is attorney-client privilege. Attorney-client privilege. This is basically whatever a client says to his attorney, that is privileged. Attorney cannot use it against his client in a court of law. So this is attorney-client privilege. And your third aspect is privileged communication by the state in the interest of justice, in the interest of public. In the interest of public. Up here, all the official communications that have been made by the state, that will fall under this category. So all the official communications that have been made by the state will fall under this category. For example, this Rafael case, the documents that were presented, the documents that were of the defense, that were there with the defense ministry, that were privileged, because they held that these, if we disclose these documents, ultimately the interest of public will be affected. Okay. So all the official communication, all the secret communication, official communications, which if they are disclosed, they will affect the interest of public. So these communications shall not be proved or disclosed in the court of law. You are prohibited from disclosing such communication in the court of law, even though these communications are relevant. भले ये relevant हो, तब भी आप prove नहीं कर सकते. Then also you cannot prove. Even though they are relevant, then also you cannot prove these communications in the court of law. So now these are certain things which are relevant, but the act says that we cannot allow you to prove them. We will not allow you. We are prohibiting you because there is an element of malice, or the relationship between the parties is such that we cannot, the relationship is of confidence, or public interest is involved. We cannot allow you to prove these facts. If the information is revealed, harm will be caused to the public. So we cannot allow you to reveal such facts. Okay, so these are the things what to be proved. So ideally, you are supposed to prove relevant fact and fact in issue. But if it is an admission or judicial notice, you need not prove. Just if you are making the admission, that is enough. Fine. Then comes relevant fact. What are the relevant facts? Then comes certain facts which shall not be proved. Now, here the act clearly prohibits you from proving these facts. So these are confession to police officer, confession in police custody, and certain privileged communications. Is this clear now? Is this clear?
Yes, sir.
Sir, but if it is forced under, but if it is forced, that will fall under separate provision, Anando. That will fall under separate provision. Don't worry about it. That will fall under 24, 25. That we'll read in greater detail. Wait. So this is basically what to prove. Now the second question, coming to our second question, that is how to prove. So the act says that you have two means. One, you can prove through oral evidence. The second, you can prove through documentary evidence. अगर चाहो तो document लेके prove कर दीजिए. So you can prove through oral or documentary evidence. Now, second question is, who is to prove? The person upon whom the burden of proof lies. Who has the burden of proof? That person is to prove. Now, the concept of burden of proof has been exhaustively dealt in 101 to 111A. Okay. So let's proceed further. Now let's understand the basic terms or the important terms in evidence law. One of the most important terms in evidence law, there are three main important terms in the entire evidence law. These three terms are defined under section 3. One term is fact. the other is fact in issue, and then comes relevant fact. Fine. So firstly, you need to understand what exactly fact is. See, that the definition of fact is worded in such a manner that it has two aspects. One is physical fact, a physical aspect. Now, physical aspect is anything that you can feel or you can perceive through senses. Anything that you can perceive through senses. Now, for example, you saw a person committing murder. This is a physical fact. You have seen a thing. So you are perceived, anything that can be perceived through senses is a physical fact. You smell gunpowder lying near the building. This is a physical fact. Smell. You felt injury. Physical fact. So all the facts that can be perceived through senses are physical facts. जो भी चीज आप you can anything that you can perceive through senses or your five senses is a physical fact. Now the second fact is mental fact. Now mental fact is a psychological fact. Now here in these facts will your intention fall, knowledge, reason to believe, dishonesty, good faith, all these will fall under the mental fact. These things cannot be seen. These are psychological fact of a person who is conscious. So these are psychological facts. Now the problem here is that fact is a very broad term. Fact means any fact. Fine, very broad term. Now the Act clearly says that only fact in issue has to be considered. Act says that only fact in issue has to be considered and relevant fact, not all facts. Only thing that you have to prove is fact in issue and relevant fact, not all fact. सब कुछ प्रूव करने की जरूरत नहीं, आपको सिर्फ fact in issue and relevant fact prove करना है. Now let us understand what exactly fact in issue is. And for fact in issue is the most important element. See, if I have to tell you in a layman's term what is fact in issue, I will say that it is the main fact in a particular matter or the most important fact in a particular matter. किसी भी matter में it is the most important fact in a particular matter. For example, such a thing happens that एक second, just give me a second. ठीक है. Suppose such a thing happened that A is accused of shooting B, ठीक है, and as a consequence of this shooting, B dies. Now, as a consequence of this shooting, B dies. Now, in this case, what is the fact in issue or the most essential fact? सबसे important fact क्या है? अब इस केस में the most important fact is A killed B. Fine. If you have the evidence to prove this, then game over. You have proved the entire thing, right? If you have an eyewitness to actually establish that A killed B, it's the end of the game. Secondly, A intentionally killed B. Intentionally killed B. So if you have the eyewitness to prove these two things, game over. A will be held liable for murder. Fine. So these two things, A killed B and A had the intention to kill B, are fact in issues. These are your main facts. Now, when I say main facts, these are those facts which actually create right or liability of a party. ये वो facts हैं जो actually एक right और liability create कर रहे हैं. अब in case में, if you prove that A killed B, A will be liable, which is creating a liability. A will be liable for murder. Fine. If you prove A intentionally killed B, he will be liable for murder as well. So these are the facts which create a right or a liability of a person. So these are the most essential or the most important facts in a matter, either a criminal matter or a civil matter. Suppose in a civil matter, let's take for civil matters. So you can basically say, first let us read the thing. So you can basically say that these are the most essential or main facts which determine the right and liability in a case. So ye right and liability, they're actually establishing your right and liability. Not only they determine right and liability, but they determine the nature and extent of this liability. Matlab, how much liability that person has. So not only they determine right and liability, they also determine the nature and extent of liability. And extent. Nature and extent, matlab, how much punishment a person is to be given. So now here, suppose what happens, A does not shoot B. Rather, A murders B or A kills B in such a gruesome manner that he cuts every body part of his, and he puts it in a sack and he throws it in a river. Now here he has committed a gruesome crime. He has killed him in a gruesome manner. Okay? He has cut down his body parts, he has put it in a sack and he has thrown it into river. Such a gruesome act. So now this fact will also act as a fact in issue, because this fact will determine his extent. Now you will consider the manner in which he actually committed the crime. So you will ask a question that A killed B in a gruesome manner. If he killed B in a gruesome manner, then you will give him death. If he does not kill him in a gruesome manner, then you will give him life imprisonment. So now here, this fact is deciding not the liability, not the right. Liabilities are decided already by these facts. This fact is deciding your extent. Ki kitni liability deni hai? How much liability are we supposed to give him? What liability? How much liability should we impute upon this fellow? So they say that, see, if it is a murder in gruesome, then we can hold him for death. This will fall under the category of rarest of rare case. Okay. So see, fact and issue are not only those facts which determine the right and liability, but also those facts which determine the extent of right and liability. सिर्फ right and liability determine नहीं कर रहा है, but उसकी हद कितनी है, कितना liability आप impute करते हो, वो भी determine कर रहे हैं. Fine. So these are your fact and issues. Now in civil cases, how will we analyze these fact and issue? See, in civil cases, you will analyze on the basis of cause of action. एक सेकेंड रुक जाओ गाइस, समझ रहा है ना, मैं ऊपर तो नहीं जा रहा. समझ रहा है ना? Are you guys able to understand? Yes sir. ठीक है. Wait, things will get more clearer when we do a few case laws. I have a lot of case laws. You will enjoy these things. Just give me a second. ठीक है. अब in civil cases, this is in criminal cases. You are actually analyzing a fact and issue. How will you analyze in a civil case? Now let us see civil case. Now in civil case, suppose such a thing happens that A and B entered into a contract. A and B entered into a contract. This is contract. Okay, A and B entered into a contract. What happened? B breached this contract. Okay. Now here, what will be the fact issue? What will be the essential facts? Now the essential facts to hold A's liability, to create A's liability, will be first, A and B entered into a contract. ठीक है, contract होना चाहिए ना, सबसे main चीज है contract होना चाहिए. Then only the first thing is that there should be a contract, and then only there can be a breach. The second thing is B breached this contract. Now to create B's liability, to create B's liability, you will have to prove these two things. So this is your fact and issue. These are the most important, most essential facts. Fine. Now the third thing is damages. Now you have decided the liability. You have said that, okay, B is liable. Now the second thing is damages. The quantum of damages that is to be quantum of damages that is to be offered. That is to be offered. To be offered. Now, this decides the extent of liability. Extent of liability. So, therefore, this will also act as a fact in issue. Okay. So, not only those facts which create or which determine the right and liability, not only those facts which determine right or liability, but also those facts which determine the extent of right and liability. सिर्फ वही facts नहीं जो right and liability को determine कर रहे हैं, but also those facts which determine the extent of right and liability. Now, please repeat the third point. Okay. Third point is that, see, quantum of damages that is to be offered to A. How much amount will you, now he has breached, B has breached the contract, right? So you will have to, B will have to pay some amount to A. Now the question is how much? So this how much will also be a fact in issue. This will also be a fact in issue. The quantum of damages will also be a fact in issue because this is determining the extent of B's liability. Kitna B liable hai, that is what it is deciding. So these are the two things that you have to keep in mind. That a fact in issue is the most important fact, the essential fact. If it is proved, then it is game over. And it does two things. First, it determines rights and liabilities. It determines rights and liabilities. Okay. Secondly, it also determines the extent of right and liability. Extent of right and liability. And liability. So this is what fact in issue is. Fact in issue is the most important fact. The most important fact. Fine. Now see, now not always you can get the evidence of fact in issue. Not in all case you will have an eyewitness who actually saw A murdering B. Fine. So not always you will get the benefit of this only proving fact in issue. So you'll have to prove other facts also. So these facts, now if you cannot get the evidence of fact in issue, you can prove other facts which are connected with fact in issue, which have a logical connection, which have a connection with fact in issue. These facts are known as relevant fact. So the facts which have the connection with fact in issue are known as relevant fact. Now, for example, A killed B. Okay? A killed B. Now here the fact in issue is A killed B, A had the intention to kill B. Two fact in issue. No one saw this event. No one saw this event. But what happened? They started shouting. Here the bystanders, they started shouting that, oh, B has shot someone. A has shot someone. A has shot someone. Okay. They did not see the event, but they heard A. They saw A shooting, but they did not see that he was shooting B. So they saw that, oh, A shot someone. And they started shouting, "Arey, A ne goli maar di, A ne goli maar di." Now this fact is close. This is fact in issue, and this fact is closely connected with the fact in issue. This fact is closely connected with fact in issue. Therefore, this is relevant fact. आप इसको relevant fact बोलोगे. You will call this relevant fact. This fact has a close connection with the fact in issue. For example, there is this fellow. He entered in a house. He entered in a house. Wait a sec. He entered in a house. Okay? And he exited the house. Fine. While he was entering the house, A saw him entering. This, let us name this fellow B. A saw B entering. Okay? When he entered the house, he murdered C. No one saw. No one saw that act because it was inside the house. When he exited the house, he was seen by one D. D also saw him. Now his entry to the house and exit to the house are so closely connected with this fact in issue that the entry and exit will be relevant fact. So ये जो exit है, that will also be a relevant fact, and his entry will also be a relevant fact. Because they are so closely connected with the fact in issue, they have a logical connection. Logically सोचो ना कि this fellow went inside and he came outside. Fine. And when he came outside, C was found dead. No one saw the fact in issue. No one saw the main fact. But we saw the surrounding facts, and these surrounding facts have a close connection with the fact in issue. So these facts will be relevant facts. So here entry and exit will be relevant fact. Is this clear, guys? So basically your relevant fact in issue, your relevant facts are those facts which have a close connection with the fact in issue. So which have a close connection with the fact in issue. You can call those facts as the relevant facts. These facts have a close connection with the fact in issue. Now, this is how fact in issue is defined in section 3. We'll do when we begin our lectures, we'll analyze each and every point: existence, non-existence, nature, and extent. But if you want to put it simply, the simple term is existence. Any fact which establishes the existence of right, liability, or disability. Any fact which establishes the non-existence of a right, liability, or disability is a fact in issue. To put it very simply. Fine. This is how the word fact has been defined in evidence law. This fact is your physical fact, anything, state of thing, or relations of thing capable of being perceived by senses, and any mental condition. This is your mental fact. And this is how relevant is defined. One fact is said to be relevant to another, which is connected in various ways, which has been provided in section 5 to 55. Fine. Please go to the previous slide. This one. This one. This one, Divya. This is the definition. This is definition under section 3. So these things, when we begin our lectures, I will explain each element in a greater detail. Okay, because of the paucity of time, I have to cover 3 cases also. So I am moving a little fast. ठीक है, समझ तो आ रहा है ना आपको? Are you guys able to understand? बोर तो नहीं हो रहा है? ठीक है, चलिए, let's start. Now see, I have 3 cases, and in all these 3 cases, I want you guys to extract relevant fact and fact in issue. Now, always keep in mind, fact in issue is the main fact, which is required to be proved. Fine. Your relevant fact are the facts which are connected to the fact in issue, which have a logical connection. In fact, through these relevant facts, you can prove the fact in issue. Relevant fact के द्वारा आप fact in issue prove कर सकते हो. So basically, through these relevant facts, you can prove the fact in issue. ठीक है? So basically, you have 2 facts. You have relevant facts. You have fact in issue, that is the main fact. Now, in all cases, you will not find evidences of directly fact in issue. In such cases, you will have to prove fact in issue through relevant facts, RFs. Okay? So basically, you can say that these chain of circumstances together, which are ultimately resulting into the fact in issue, which are ultimately resulting into the conclusion of the fact in issue, is known as relevant facts. These have close connection with the fact in issue, and ultimately they are trying to prove fact in issue. These things are ultimately, हम क्यों prove कर रहे हैं कि this fellow, why are we proving that this fellow went inside the house and he exited? Because we want to prove the ultimate fact in issue, the main thing. So that is the reason we are connecting all the fact in issue to reach, we are connecting all the relevant fact to reach to the fact in issue. हम सारे कड़ियां relevant facts के जोड़ के fact in issue तक पहुंचना चाह रहे हैं. ठीक है? In all these cases, this is what we will do. In all these cases, this is what we'll do. And let us start with this. Santosh Kumar Singh versus State through CBI. This case is also known as Priyadarshini Mattu case. And this is a Supreme Court judgment. Judgment was pronounced by Justice H.S. Bedi and Justice C.K. Prasad. In this case, what had happened? There was Santosh. There was this one fellow whose name was Santosh, and there was Priyadarshini. They both studied in campus law, CLC, that is Delhi University, campus law campus law school, law college. Sorry, that is CLC, that is Delhi University. So Priyadarshini was junior to Santosh. Okay, and Santosh was the son of police commissioner. Now these are the backgrounds that we are discussing. Santosh used to follow Priyadarshini's car on a bullet motorcycle. So he was stalking every day Priyadarshini. What happened? Santosh graduated and he enrolled in an LLM in ILI. In ILI. So now he is graduated, he has enrolled in an LLM in ILI. Even after his graduation, what this fellow is doing, he keeps visiting Delhi University just to see Priyadarshini. Now, Santosh harassed Priyadarshini, and despite many requests, okay, please do not follow me, please do not irritate me, he did not stop. So what did Priyadarshini do? Priyadarshini filed a police complaint, and accordingly, Santosh was advised to behave. Santosh was asked, okay, boss, you will not follow her, you will not annoy her. And Priyadarshini was so threatened by Santosh that the police authorities actually gave her a personal security guard who was a constable, who was of a constable level. Okay, in case something happens, so you take care of this issue. So now what happens in retaliation? This is in retaliation. Santosh ki complaint kar di, and his name was spoiled. So in retaliation, Santosh filed a complaint with university that Priyadarshini is pursuing 2 degrees. You were not allowed to do back then. I don't know about the current position, but back then you were not allowed to do that. So because of this complaint, Priyadarshini's 5th semester result was withheld. They did not declare that result. Fine. So this is the background basically. So the background is that Santosh and Priyadarshini were studying in campus law college. Santosh was junior to Priyadarshini. Santosh is also a son of police commissioner. Santosh used to stalk Priyadarshini and he used to harass her. Santosh graduated, but still he used to come to CLC just to harass and stalk Priyadarshini. Priyadarshini got annoyed. She filed a complaint. And on her complaint, she was also given a personal security guard. Santosh, in retaliation, filed a complaint with the university that Priyadarshini is actually pursuing 2 degree courses, and therefore her 5th semester law result was withheld. Fine, this is the background. Background is clear to everyone? Background clear? Hai? Background is important because these are facts, right? These are all facts. Now the question is what is relevant and what is fact in issue. वो भी important है. अब आ जाओ आगे. Let's see what happened on the day of occurrence. That is 23rd January 1996. Now what happens here? Priyadarshini reached and she saw Santosh present outside the campus. Okay. She attended the lecture at 11:55 to noon. That is around 2. And then she went home. So on that day, usual day, she went to college. She saw Santosh present outside the campus. She attended the lecture and then she went home. And when she went home, she told the constable, that is the personal security guard, that you go home and you can come again at 5 o'clock. Okay. She had lunch and then domestic help, that is the person who was working in her house, domestic help left at 2:30 p.m. Okay. So now here, this is the time when she's alone. So she asked police security constable to leave and come around at 5 p.m. And she had lunch. Then domestic help left at 2:30. अब यहाँ से start होता है. Then what happened? Santosh came at the home of victim at about 4:30. Okay, 4:50. He was carrying a helmet, and this particular fact was seen by a security guard. That Santosh is entering, this was seen by security guard. Santosh entered the house. Santosh committed sexual assault on Priyadarshini and then caused her death by using the helmet. He caused death by using the helmet. At 5:30, that is 40 minutes later, Santosh exited the building, and this was witnessed by neighbor. This his exiting the building was seen by neighbor. Fine. Now what happened? Constable returned and he started pressing the bell. He started ringing the bell, and no one attended the door. No one was opening it. So he got worried. So he entered the premises through the neighboring house. If you have been to Delhi mein most houses are built in such a manner that they are adjacent to each other. So if you are entering this house, you can go to the other house through uh, by climbing on upon the terrace to the other house. So constable entered the other house through the neighbor's house. So he went to neighbor's house and he entered to this Priyadarshini's house. Okay, because he was not attending the door. Now let's see what happened to her. Yeah, the clear, guys? Okay. Let's see what happened to her. Let's proceed further. So upon entering, the moment he entered, he found her dead body lying under the double bed with a cord of electric heat converter tied around her neck. He noticed blood stains around her body. So he found her dead body under the double bed. Now, what happened after this incident? Now cut back to Santosh. Let's see what is Santosh doing. Now cut back to Santosh. Santosh, the moment he has committed this crime, the moment he has exited the building, he goes to attend his lecture, which was scheduled at about 5:30 in ILI. He's doing LLM, right? So during that period, ILI lectures were held in the evening. So he went to attend lecture, not because he's obedient, but because of something else. I'll tell you. So he went to attend his lecture at 5:30, even though he was late. So what happened in ILI earlier? The moment you are entering, you had to write down the time when you are entering. You had to write down the time when you are entering. So he entered his entry time as 5:30. The college official objected. College said that why are you entering 5:30 when it is already 6 o'clock? But he did not change it. He did not change it. So he attended the lecture not because he is obedient, but because he wanted to create a fake alibi that he is somewhere else. So now what happened? Now let's get to what is police doing. So Priyadarshini's mother filed a complaint and an investigation started. And according to investigation, and on investigation, Santosh was questioned. So the police asked him that how did he get this fresh injury? Police asked him that how did he get his fresh injury? He had an injury on the hand. So Santosh said that he met an accident. Santosh ne bola कि he met an accident. So police called Santosh here, and he said that he had met an accident. That is the reason he has this injury. Now what happened? Police found the visor of the helmet. आपको पता है what is visor? This is helmet, and there is this small plastic coating upon the helmet. So police, that is known as visor. So this visor, the pieces of visor were found at Priyadarshini's house. The pieces of helmet were found on Priyadarshini's house, and this helmet which he was carrying, which this Santosh was carrying, had the contours of skull. Matlab, it had nishan ban gaye the skull ke, human skull. It had the contours of human skull. So the police actually collected that helmet, and police actually examined the visors also. Okay. So then what happened? Then blood stains of victims were found on helmet. The blood stains of Priyadarshini were found on helmet. Pieces of visor were found at Priyadarshini's home. Then vaginal swabs and underwear of the deceased, underwear of the person who has died, was taken, and it was established that rape was conducted by Santosh. Okay, they matched the vaginal swabs and they matched the underwear of the deceased, and they ultimately found that rape was committed, and that was committed by Santosh. Now, if you had to decide this case, now tell me what are the relevant facts? What is fact in issue? First, tell me what is fact in issue. What is fact in issue? Tell me. इसमें बताओ. Fact in issue, most important fact. Priyadarshini and Santosh committed a sexual assault upon Priyadarshini. These are the two main facts. Now, what all things you have to prove this fact? Now, what all things? See, no one has seen the fact in issue. No one has seen him killing. So you'll have to rely upon other relevant facts which are closely connected with the fact in issue. Now, let us examine all the closely connected fact in issue. तो पहला है your fact in issue is causation of death and intention of cause death, and also sexual assault. That whether that sexual assault is also a fact in issue. Now the thing is that what are the relevant facts? The most important relevant fact is that this fellow was trying to create an alibi. Now, what does alibi mean? Alibi means that when the crime was committed, you were somewhere else. When the crime was actually committed, you were somewhere else. So this fellow is actually trying to create an alibi. Now, how is he creating an alibi? That you have to understand. He's creating an alibi when he went to that ILI. He went to attend that lecture. On the register, he wrote 5:30. But when he exited Priyadarshini's house at 5:40. So he purposely wanted to create an alibi. He was trying to create a false alibi. So this is a relevant fact. Why would he create a false alibi if he hasn't committed any offense? Why would a person lie? Why would a person wrongly insist upon entering a wrong time when he has not committed any offense? Secondly, he had motive. He had motive because he was interested in Priyadarshini, and Priyadarshini has denied, and she had filed a complaint against him. So he had a motive. Plus his previous conduct, following the accused, stalking, that was clearly establishes that he wanted to commit this crime. Secondly, his subsequent conduct. After commission of crime, what did he do? He lied to the police. When police asked him that what happened on the crime scene, when police asked him that what happened to your hand, he said that he met with an accident. And when reality, it was found that he has committed this offense. So this is also a relevant fact. And the most important relevant fact is last scene theory. Last scene theory. Now try and understand. There is this house. Here, Priyadarshini is there. Fine. And Santosh enters this house. The moment he leaves, Priyadarshini is dead. Okay. Now, Priyadarshini was last seen alive with whom? Santosh. Now, the burden is upon Santosh to establish that what happened to her. What happened to her after this? So, the burden is upon what happened to her. So, this is the last scene theory. And then comes effect of fact and issue. One fracture upon his hand. He tried to hit her with the helmet. So ultimately, he sustained some of the bruises, including the fracture. Marks on helmet, contours of skull, pieces of visor that were found in Priyadarshini's house. All these relevant facts link to one thing, that is fact in issue. All these relevant facts tilt towards fact in issue. That fact in issue has been done by this fellow. And then they conducted a DNA test. And in DNA test, they found that the blood sample that they found from this helmet blood stains that they found on helmet, and the blood of Priyadarshini was same. So after conducting DNA test, that blood also was same. So in this case, what will you hold? Will you convict the accused or acquit? Bataiye, what will you do? Convict or acquit? Convict. Everyone convict. Yeah, ideally you should convict the accused. But what had happened, this case had an interesting turn of events. Session court acquitted Santosh. Session court acquitted Santosh. ठीक है? Session court acquitted Santosh. And Santosh started practicing law. He married some girl. He had a daughter as well. And Session court said that the facts are not, there is lack of evidence. Evidences are not sufficiently proved. So they acquitted. So one fine day, what happened? High Court saw this file. Delhi High Court saw this file. And Delhi High Court said that what has happened? How can you acquit such a person? The evidences or all the relevant facts are so closely connected that they are completely tilting towards the fact and issue. How can you acquit such a person? So High Court took suo motu cognizance. High Court took suo motu cognizance and they decided this case again. And High Court convicted him. High Court gave him death. High Court also gave him death. And then he filed an appeal before the Supreme Court. Now, Supreme Court upheld the conviction. Supreme Court said that the conviction by the High Court is correct, but they reduced this death to life imprisonment. They reduced this to life imprisonment. And this was the reason they gave. They gave that, see, the appellant was a young man of 24 at the time of the incident. And after acquittal, had got married and was a father of a girl child. Undoubtedly, also the appellant would have had the reflection over the events for the last 15 years and to ponder over the predicament that he now faces. The reality that his father has died a year after his conviction and prospects of dismal future for his young family. There is nothing to suggest that he would not be capable of reform. So therefore, the Supreme Court converted this death into life imprisonment. Okay? So he was convicted, but he was given life imprisonment. Is this clear? ये आपका पहला केस है. क्लियर है ये? आगे बढ़े. ठीक है. Miscarriage of justice by lower court. Yes, definitely. Now see, there is one case which shakes my conscience. In fact, this case is nothing if compared to that case. Ideally, we should not compare atrocities, but this case is one which shakes my conscience. And the case name is Govind Swamy versus State of Kerala. Now, the judgment in this case was delivered by Justice Ranjan Gogoi, Justice P.C. Pant, and Justice U. Lalit. Justice P.C. Pant is one judge who became a Supreme Court judge, and he's one judge who was elevated from judiciary. As in, he was civil judge junior division, he was judicial magistrate first class, and then he became a district judge, then he became a high court judge. So he was never an advocate, he was always a judge. So right from the start, he started his career as a judge, and he went to Supreme Court and was elevated to Supreme Court also. So it's possible a judicial magistrate first class can also become a Supreme Court judge if his service is long enough and if his work is good. Okay. Sir, how is it also, sir, how motive is relevant fact? Wait. Father died a year. Wait a sec. Sir, how motive is relevant fact? Motive is relevant fact because he was talking, and the woman this Priyadarshini, she has denied. So he had a reason to actually commit this crime, and further Priyadarshini had filed a complaint against him. So he was all the more enraged, and he had this motive or the reason to perform such an act or do such an act to her. Fine. Is this clear? Father died a year. See, basically what the court is trying to say here. Court is trying to say that, dekho, why we cannot give death. We cannot give death for two reasons. One, after acquittal, he has reflected upon himself. He has married. He is a father of a girl child. Secondly, just a year ago, his father died. Sorry, his father has died. Sorry, his father has died after the conviction. So now the young family that he has, that is the woman and girl, they are already in a they have a bleak future. Unka future बहुत खतरे में है. So if we will give death to this person, it will be even more. We are doing bad to that family. Fine, is this clear? ठीक है, चलो. So start करें ये. चलिए सर, PDF चलिए स्टार्ट करते हैं. ये ध्यान से सुनो guys, this is very important. Now here what was happening, Soumya was working in Ernakulam, that is in Kerala, and she was engaged to Anup. Fine. And their betrothal ceremony, that is the engagement ceremony, was to be conducted in the house of Soumya, and her house was in Shornur. So basically she was working, wait, let me bring a black pen. So basically she was working in Ernakulam. And betrothal ceremony was to be conducted in Shornur. So working in Ernakulam, betrothal ceremony on Shornur on 2nd February. Fine. So therefore, because betrothal ceremony was there, so she had to travel to Shornur. So on 1st February, she boarded this Ernakulam Shornur Express at about 5:30 p.m. Now, Soumya had boarded the ladies' division of the last compartment. Now, you need to understand, there is this compartment which is general, which has all male and female, but there is a division specifically for ladies. In this compartment, there is a specific division for ladies. This specific last compartment में एक division for ladies. So Soumya boarded this ladies division of the last compartment. So this is a ladies division. This is not a ladies compartment. This is a ladies division of the last compartment. Fine. So then what happened? The train stopped at Mulurkara. All the lady passengers in the lady division alighted. They left. So Soumya too got down. So see, all the ladies in the lady division, they left. So she was scared. So she got down and she entered the ladies coach. Now this is complete ladies coach. This is full ladies coach. Fine. So she entered this ladies coach, which was just in front of the last compartment. So this was ahead of this last compartment. Fine. Now let's see what happened. This is clear, right? This is clear. Background. This is background. Let's see what happened then. Thereafter. Wait a sec. Oh. Okay. Now let's see what happened. So train reached Valathol and it halted there for some time. Now there was this fellow Govind Swami. Now Govind Swami is a person who is partially handicapped. His hand is not, as in his hand is tilted. It's not in its right shape. So Govind Swami noticed that Soumya was alone. So he entered the ladies' compartment as soon as the train left Valathol and moved towards Shornur. So he entered the ladies' compartment as soon as the train left Valathol and it moved towards Shornur. So what did Govind Swami do? When he entered the compartment, Govind Swami hit Soumya on her head. She banged her head on the walls of the train, the side of the train, and which ultimately dazed her. So Soumya started screaming and shouting. Okay, he took her head and he banged against the wall of the compartment. So which dazed Soumya. And ultimately she started screaming and shouting. Then what did he do? He pushed Soumya from running train. Now when he pushed Soumya from running train, what happened? Her face, now when he pushed her at a position wherein the train was changing its track. See, there is this position, no? When there is this situation wherein the train changes its track. So what happened? When he pushed her, Soumya's face hit this track. Soumya's face hit this track. In fact, her face was in such a condition that her that 15 of her teeth broke. Okay. Then what happened? The accused jumped from the train as well. Now the train was moving in a slow motion; it was not very fast. So he jumped from train as well, and the accused, this fellow, he lifted Soumya and he took her to another side of the track. He took Soumya to another side of the track and he sexually assaulted her. Okay, and he sexually assaulted her. Then what happened after sexually assaulting her? He ransacked or took her belongings and went away with her mobile phone. Fine. This is the act of crime. Fine. यहाँ तक क्लियर हो? ठीक है. There is no why in this. Why did he do it? We cannot say why did he do it because that is silent. That part is silent. So let's proceed further. Now let's see what evidences do we have. Now in this, what was happening? That there were two people. One was PW4 and PW40. They were also traveling in the same train. Okay? They were also traveling in the same train, and they were in the general compartment that was in front of ladies compartment. So this is general compartment. They were here, and this was the ladies compartment back. Now these PW4, these are two witnesses, PW4 and 40. They heard cries of Soumya. They heard Soumya shouting, and they wanted to pull the chain. They asked each other, should we pull the chain? But they were stopped or dissuaded by a middle-aged man. Middle-aged man said that, no, don't pull the chain. And middle-aged man said this. And this part is very important. Middle-aged man said this. The girl had jumped out from the train and escaped. In these circumstances, he should not take matter any further, as the same may drag all of them to court. Fine. So PW4 and 40, they said that, see, they are hearing cries of Soumya. They wanted to pull the chain. A middle-aged man is standing near the door. He says that, why are you pulling the chain? The girl has jumped and she has already escaped. If you pull the chain, we will all be dragged to court. Now what happened? These PW4 and 40, they were scared. The moment train reached Shornur, where is the pen? Ek second, where is pen? Yeah. The moment train reached Shornur, PW4 and 40, they went to the guard of the train, and they asked her that this all has happened. They told her that this all has happened. So what did the guard do? Guard triggered the search for Soumya and Govind Swami both, and they found them. Soumya was badly injured. She was lying by the side of railway track. Her clothes were torn, face was mutilated, teeth were broken, around 20 teeth were broken. She was taken to the hospital, and then she died on 6th February. She died on 6th February. Fine. Clear, yahan tak? Till here it's clear? I didn't get the track part. Wait. One second. I didn't get the track part. Are you talking about the moving track? See, what happens when the train is about to reach a station? So it changes its track. Okay, this is suppose somehow it goes somehow like this, and then they enter into a new track. So what did this fellow do? So it is this situation when both the tracks come so near. ये ऐसा समय होता है जब दोनों ट्रैक्स बहुत ही सामने आ जाते हैं. So if someone throws in such a situation, he is bound to hit the tracks. ठीक है. Ideally दो ट्रैक्स के बीच में स्पेस रहती है, but ये जब ऐसा होता है when the train changes the track, both the tracks come so close to each other that if a person is thrown or if a person jumps, he is bound to hit the tracks. So ये था tracks वाला part. Clear? ठीक है. Let us proceed. ठीक है, आगे बढ़े। चलो अब देखते हैं क्या क्या मिला है इन्हें एविडेंस में. What all they have found as evidences. What all things they have found as evidences. The first thing is that vaginal swabs and vaginal smears were collected. Vaginal swabs and smears were collected. Blood samples of Soumya was also collected. Her garments are also collected. And seminal stains of Govind Swami were found on the garments of Soumya. जो सीमेन के स्टेन्स हैं सौम्या के गारमेंट्स पे, they were found. The seminal stains of Govind Swami were found on Soumya's clothes. Now Soumya's blood was found on Govind Swami's clothes. So seminal stains of Soumya were found on seminal stains of Govind Swami were found on Soumya's garment. ठीक है, सौम्या का जो गारमेंट था उस पे seminal stains of Govind Swami's were found. And Soumya's blood was found on Govind Swami's clothes. ठीक है, is this good piece of evidence? आपको क्या लगता है, बहुत ही अच्छा है या ठीक ठाक है? बताइए, what do you think of this evidence? ठीक है, अब आगे देखो. आगे what had happened? The moment he ransacked her belonging, he stole Soumya's phone. This fellow sold this phone to Baby Varghese, one person, Baby Varghese, from whom the police seized it. Okay. Now these were all the facts that you have before you. Now tell me what is fact and issue in this case. Fact and issue क्या है? What is fact and issue? Rape. Only rape. She died also, na? He raped her. Only rape. She died also. Killed and raped. Murder and rape. Yep. Govind Swami committed sexual assault as well. Fine. Raped and killed. So yes, you have three. Here you have fact and issue for three things. One is for murder. Second is for rape. And third is for theft. ठीक है, that is 379. So you have first is, this is for murder, and then you have for rape, and then you have for this theft. So you have three fact and issues basically. Theft too, definitely. Now let us see what are the relevant facts which are required to prove. So first is that what had happened, Govind Swami noticed that she was alone. So Govind Swami entered. So her being alone acted as a occasion, which ultimately gave the opportunity to Govind Swami. So her being alone in the compartment acted as an occasion which gave Govind Swami an opportunity. Secondly, effect. Injury number one dazed her. ठीक है, there is एक bang करके which there is an injury which ultimately dazed her, and then she was pushed from train. ठीक है, that is a condition precedent. Now she was pushed from train, and thereafter he took her aside and committed rape. So this pushing from train is condition precedent, मतलब prior to commission of this fact and issue, rape वाला fact and issue. So first he pushed her from train. So this is a relevant fact. And then he committed rape. So this is a relevant fact which triggered this fact and issue. Then comes screams of Soumya. These are also relevant fact, right? The PW4 and 40 heard it. Then cut out garments on which seminal stains of Govind Swami were found. These are also relevant facts. Her mutilated face, which shows that someone must have either she would have herself jumped from her, or someone must have pushed her. So her cutout, her mutilated face clearly shows that. And then DNA profiling. There was a semen match. The semen on garment and Govind Swami's semen were same. There was a blood sample match. Soumya's blood and blood on Govind Swami's clothes was the same. And then there was again condition precedent of picking up Soumya. Now, what did he do? Soumya was lying there. He took her, picked her up, he took her aside, and then raped her. No one saw the rape part, but certain people saw her picking up Soumya and taking her aside. So now this picking up was a condition precedent, or a conduct previous to fact in issue. Now this conduct also triggered the fact in issue. Had he not picked her up, he would not have committed rape. So this conduct triggered fact in issue. So this is also a relevant fact because it is so closely connected with the fact in issue. So all these facts are connected. Now tell me, conviction or acquittal? Conviction or acquittal? अब वेट, अब देखो इसमें थोड़ा एक चीज है. देयर आर टू इंजरीज हियर. वन इज I2, one is I1. There are two injuries here. One is I1 and I2. Wait, to explain this better, वहाँ पर बहुत सारे चीजें हैं. There are two injuries here. There are two injuries. ठीक है. One is I1, that is injury number 1, and the second is I2, that is injury number 2. Your I1 injury is dazing. Dazing means that he struck her head on the compartment, on the side of the compartment. That is I1. Your I2 is falling. That fall. Now her death was caused by fall. I2. ठीक है? Is this clear? यहाँ तक clear हो? उनका जो डेथ हुआ था वो I2 की वजह से हुआ था. Her death was caused because of the fall. Is this clear? ठीक है. Let us proceed further. ठीक है. Now you are saying that this is conviction. ठीक है? This is conviction. Now conviction for what offenses? All three offenses: rape, murder, and theft. See, theft we are proving. How are we proving theft? How are we proving theft? Theft we are proving. How are we proving theft? Theft we are proving by recovery of that mobile phone. Recovery of mobile phone. Okay, so that is proving theft. How are we proving death? Rape we are proving because, okay, fine, there are seminal semens on garment of Soumya. There are seminal there is Govind Swami's semen on garment of Soumya. That is the reason we are proving rape. But how are we proving death? How are we proving murder? That is an important aspect. हम देखो, रेप तो प्रूफ कर सकते हैं. रेप तो हम प्रूफ कैसे कर रहे हैं? Because we have seminal Govind Swami's semen on garments of Soumya. ठीक है? So this sufficiently establishes rape. But how are we proving murder? See, murder, death certificate, definitely through death certificate. Death certificate says that the murder, death was caused due to I2. Do you have evidence to say that I2, that is the act of pushing, I2, that is injury second, that the act of pushing was actually, whether the act of pushing was actually done by your Govind Swami? क्या आपके पास कोई ऐसा evidence है which actually establishes that act of pushing was done by Govind Swami? Now the problem here is that there was no evidence to support the same. They had no evidence to impute I2 to Govind Swami. उनके पास कोई evidence नहीं था ये establish करने का कि injury second injury was caused because of Govind Swami. Now, problem what happened? देखो, what are things that are proved? They established rape by vaginal swabs and semen stains. ठीक है. They established robbery by phone that they have recovered. तो फोन से उन्होंने establish कर दिया. But murder became a problem because what happened? Your middle-aged man told them that the girl had herself escaped. Now he is saying that she herself jumped. So now, how can you impute injury to Govind Swami? Second injury, Govind Swami को कैसे आप कर सकते हो?
Sir, hello.
हाँ जी, हाँ जी, बोलो.
Sir, my thing is that even if it is that she herself has escaped, but why did she escape? Why was that she had to escape from Govind Swami? Was that event or incident not witnessed by those witnesses?
No, that wasn't witnesses by those witnesses. No, they
No,
only
they
saw
have
screaming.
seen that she had escaped. They said that she had escaped. But
Yeah.
why had she escaped? Why is the word escaped coming from?
Yeah, she had escaped because someone was she was beaten up by him, and then she escaped. Fine.
So there was this, somebody was actually, like pushing her to escape.
Pushing her
And
to escape.
that she fell down from the running train. The train could be very slow at that time, but that
Yeah.
she fell down from the running train. It is because somebody over there incited her to fall, to escape from the running train, to jump from the running train, which has actually caused her to for this kind of a severe injury that actually caused her death. So wouldn't the Govind Swami be convicted on this issue?
No, he won't be because of two things. When injury number 1 took place, let me complete now. Let me complete.
Okay, sir. Okay.
Yeah, whenever you have a doubt, raise your hands because it will be convenient for us.
हेलो.
Okay. Yeah. You
सर,
can.
मैं हिंदी में थोड़ा सा कोट करना चाहूंगा.
बोलिए.
यहाँ पे सर जो फर्स्ट इंजरी जो है वो तो हेड इंजरी में जो मारी गई थी उसके द्वारा था, लेकिन दूसरी जो इंजरी थी वो गिरने के कारण था.
हाँ, अब यही
वो गिरने के कारण था. दूसरी चीज ये चीज जो कॉज किया जा रहा है कि हाँ, या मे बी पॉसिबिलिटी कि मारा गया हो, तो मारने की कोई भी इंजरीज वगैरह शरीर पे अवेलेबल नहीं थी.
हाँ, करेक्ट. अब आगे रुको, खत्म तो करने दो मुझे. रुक जाओ.
बिल्कुल
रुक जाओ, खत्म करने दो एक बार. वेट अभिषेक. इंजरी वन was imputed to गोविंद स्वामी. गोविंद स्वामी ने इंजरी 1 कॉज की थी. दैट was established. Now we were in dispute with injury 2 कि whether he actually caused injury 2. Now court said that the moment injury 1 was caused, this dazed the victim. Victim became daisy. ठीक है. So she wanted to escape. She tried to escape and she fell. Now in this case the role of Govind Swami was negligible. यहाँ पर जो रोल है गोविंद स्वामी का वो नहीं है यहाँ पर. ठीक है. So we cannot hold him liable for murder. It may be a case that Govind Swami did not want to push her. He just wanted to keep her there. ठीक है. तो इसके लिए we cannot hold him liable for murder. और अगर हमने ये इंटरप्रिटेशन लगा दिया कि उसने मारा तो था तो शायद धक्का भी दे देता, वी आर नॉट व्यूइंग द केस प्रोक्सीमेटली. हम एक बहुत ही फार ऑफ एक्ट उसको इंप्यूट कर रहे हैं. अब दूसरा है कि क्या I2 गोविंद स्वामी ने नहीं कॉज किया. उसके लिए यू हैड द स्टेटमेंट ऑफ दिस मिडिल एज्ड मैन विच सेड दैट शी हैज एस्केप्ड. ठीक है. Had this middle-aged man or any one of these witnesses, PW4, had said that she was pushed, it would have resulted in conviction under 302. It would have resulted in conviction under 302. They could not prove that. So how can you impute that injury to Govind Swami? आप वो एक remote injury कैसे impute कर सकते हो गोविंद स्वामी को? So accordingly, Govind Swami was convicted for rape. He was convicted for robbery. He was acquitted for murder. अब इस पे समझो, हम सब विवाद में नहीं आना चाहते. मैं बताता हूँ, इसमें स्टोरी बताता हूँ आपको. विवाद में मत आओ, एक बार शांत हो जाओ. बताता हूँ मैं आपको. स्टोरी क्या हुई थी कि केरला सेशंस कोर्ट had convicted him for murder as well, and they had given him death sentence, rarest of rare case. ठीक है, High Court confirmed the same. ठीक है, case came before Supreme Court. These three judges said that, see, now there are 3 offenses, we have evidences of 2. We have evidences for 2, but the act which actually caused the death, we don't have the evidence that it was caused by the accused. वो उसका हमें वो भी नहीं है, हम ये भी नहीं बोल सकते कि उसने ड्राइव किया हो. He had because she had dazed, so we cannot just say that he had driven her also. अब इसमें they were at in a conflict, what to do, what not to do. So ultimately what happened, they acquitted him for murder, and they convicted him for rape and convicted for robbery. They gave him life imprisonment because back then rape was not punished with death. So the LI tha maximum. So they had given the maximum, that was life imprisonment. So they had given him life imprisonment, that is LI. उन्होंने दे दिया इसको life imprisonment. ठीक है. अब after the court passed a judgment, many legal scholars were angry. Many legal scholars applied escape theory, as Soma is applying, that if a particular victim is escaping because of the accused and he or she is committing the suicide, then the accused should be held liable for murder or for culpable homicide for that matter. Now this escape theory was commented by many of them, and one of the person who actually propounded or who actually went ahead with this escape theory was Justice Markandeya Kadju. पता है किसी को? फेसबुक पे देखते होगे. Justice Markandeya Kadju, he propounded, he said that, see, escape theory will be applicable, and this fellow should be held liable for murder. Not only Justice Markandeya Kadju, but also Law Minister of Kerala State. He also said that in this case you will have to hold him liable for murder. In fact, Markandeya Kadju wrote an article in which he criticized all the judges of the Supreme Court. He went a little personal with the judges, and he said that this is travesty of justice. This is injustice being done. Supreme Court has become corrupt. He said a lot of things. So this 3 judges bench, they asked Kadju to appear. They asked him to file a review petition. They treated this article of Justice Kadju as review petition. ये जो Justice Kadju का article था, this was treated as review petition, and escape theory was analyzed. Court said that, do you have evidence to support that the act was of such a nature that she was in such a nature that she had no other option but to escape? Sadly, there was no evidence on record to support the same. Escape theory was not applied in this case. It was held that escape theory will not apply. Okay? And this review petition was rejected. Now, once you reject the review petition, it is fine. But Justice Kadju has insulted judges. So he was held liable for contempt. And he was asked that, see, either you apologize or either you go to 6 months imprisonment. आपको क्या लगता है क्या चूज किया होगा जस्टिस काटजू ने? What do you think what he must have chosen? क्या लगता है क्या चूज किया होगा? अपॉलॉजी या 6 महीने जेल? इम्प्रिजनमेंट? अपॉलॉजी. कौन 6 महीने क्यों जाएगा? So this was your Govind Swami case, the curious case of Govind Swami.
Excuse me, sir.
Yeah, you guys can interview.
Yeah, sir.
Raise your hands and interview. Then it will be fine.
Yeah, I've raised already.
हाँ जी, बताइए.
Sir, what about the idea of this, sir? Brain fingerprint. I mean, the lie detector test or narco analysis of Govind Swami.
Narco analysis is not admissible in court of law. No?
And it's a lie detector test.
Nothing is not admissible in court of law. It is a violative of Article 20, Clause 3.
Okay, sir.
You cannot use it in court of law. This, when you study evidence with me, ये सब कराऊंगा आपको. Yes, Abhishek.
Yeah, already asked, sir, my question.
Let's see. Anyone else has any question? What else she could have done if not escaped? What else she could have done? So there was no evidence to support the same. No? Yes, Eliza. Yes, Eliza. Not audible. Which article? It's an article written by Justice Markandeya Karju. Now it has been struck down. He has taken it from online media. But isn't the chain of circumstances enough? There is no, in chain of circumstances, there is no part of evidence which imputes the second injury. Some evidence should be there, na, which slightly hints at imputing injury. On the contrary, there is one evidence which suggests that the woman has escaped. अब इन सब में आपको अगर विलन ठहराना है किसी को, तो if you want to declare anyone as a villain in all these happenings, so you can declare this fellow as the villain. ये बंदा. Because of him, a contrary evidence was represented. ठीक है? Had this fellow not been, things would have been slightly different. Okay, is this clear? So the chain is broken because of this fellow. चलिए आगे बढ़े. Do you want to do one more case? Yeah, let's call it a day. 3 बचे वैसे. Let's please end now. Yes, ending. Let's end it. Let's keep some things for suspense. I have a lot of cases. Don't worry. If you do evidence with me, you will. In fact, I want to start with evidence only with you guys. So we will do a lot of cases. Don't worry about it. I have a lot of cases. So anything you have for me? Do you guys want to ask? Sir, do we get this PDF? I'll send you the recording, so you'll get it. Don't worry. Recording, you'll get it. Fine. Yes.
Thank you, sir.
Yes. Thank you, everyone. Thank you. What was your final take? What was the final take? Acquittal. 7th will be your classes starting. Chalo. Bye guys. See you on next Sunday. You'll have your freelance session. Chalo. Bye guys.